some of our items that we represent. Today, we're going to be talking about a new law that was actually implemented a few years back, but the legislature gave everyone time to figure out how to comply with this regarding streaming your meetings. Thankfully, through some of our research and analysis of the statute, we believe, and I'll get into it later, that this doesn't apply that broadly to entities outside of towns, cities, and counties. But I will get into that in a little bit. The first thing I think we need to do is establish what exactly is a meeting, because can somebody mute someone doesn't have it on mute. I'm getting a lot of feedback. I think it would be helpful. Thank you. What is a meeting? So except for executive sessions, all meetings of a governing body of a public agency must be open at all times for the purpose of permitting members and the public to observe and record them. As you know, anytime your governmental organization holds a public meeting, unless there's a few exceptions to that, then that meeting has to be open to the public. And in some circumstances will now need to be live streamed. But a lot of times I think people more narrowly define what their meetings are. This is a definition of a meeting under Indiana statute. A meeting is a gathering of a majority of the governing body of a public agency for the purpose of taking official action and public business. Those are two important phrases: official action and public business. So a meeting is not certain things. A meeting is not a social gathering, on-site inspections. I come across this one a lot with like redevelopment commissions when you go to visit sites. Those are not public meetings. Traveling to and from those meetings are not public meetings. A caucus, a gathering to discuss a commercial prospect does not include conclusions or recommendations. This happens a lot in the economic development world when you're trying to kind of come up with an incentive package to incentivize an organization to maybe come to your community. And collective bargaining discussions. Those are not meetings under the statute. What we discussed before is one of the qualifications for it to be a meeting is you have to take official action. So this is a very broad term. It means receiving information, deliberating, making recommendations, establishing policy, or take official action. So one thing you'll notice here is that just simply receiving information is actually an official action under the statute. So if you're just meeting to get a report on something, that is a public meeting. You're just receiving information. And the other test is public business, but this is very broad. It means any function upon which the public agency is empowered or authorized to take official action. So anytime a quorum gets together to pretty much do anything that is to take official action, which means to get information or take action, and it's regarding something that that entity or board is established to do, that is a public meeting. This is something that I think a lot of people don't practice, is that a meeting of a committee can also be a public meeting. So if a committee is appointed by a governing body to take official action, which again, as we talked about before, could be simply receive information, that is a public meeting that needs to be open to the public. And I think this one is probably one that's the most overlooked. I'm not suggesting you go out and make all your committees public right away, but I would consult your attorneys about that if you have any concerns. I think we're all probably familiar with executive sessions. These would never need to be streamed or recorded. These are not open to the public. These are specifically meetings that can be called under statute for very specific reasons that are not open to the public and therefore would not be subject to this new law. And I think executive sessions can be sometimes overused and sometimes be underused. I think that sometimes municipalities call executive sessions just because they want to talk about something in private, but you need to make sure that you fit into one of the exceptions. These are a few of the very common used ones. Litigation, either pending or threatened, to discuss that. It can be an executive session. Purchasing real estate or discussing a real estate transaction can be an executive session. Negotiations with a commercial prospect. This is kind of double counting the one that's not even actually meeting. Employment issues are also a reason for an executive session. So anytime you would hold an executive session, this new law would not apply to streaming those meetings. My slides are frozen, so excuse me here. There we go. And again, no official action can be taken in executive session, so that's probably one of the reasons the legislature says they're okay to have. You have to go into a regular meeting to be able to actually take action. And finally, before we get into the new law, the courts, the law really favor openness. These laws are liberally construed to be open. So, you know, when in doubt, you resolved in favor of openness, and that's what the way the law prefers it. So the reason we kind of came here today is this new law. I've answered a lot of questions over this over the last several months and years, because this has been out there for a couple of years. The new requirements for live transmissions and archiving of meetings of governing bodies. Okay, this applies to the following agencies. A governed body of a state agency, so any state agency, doesn't apply to most of us. And the following: the executive, the legislative, or the fiscal body of a county, city, town, or township. Or any governing body that conducts their meetings in the same meeting room as the executive, legislative body, or fiscal body of a county, city, town, or township. So for example, if you are a regional sewer district, this generally would not apply to you because you are not the executive, legislative body, or fiscal body of a city, county, town, or township. However, if you hold your meeting in your county councils or county commissioners' chambers, this law does apply to you because of where you hold your meetings. We had a lot of back and forth trying to really narrow in. And I know that I was on stage at an Alliance meeting several months back, and the lobbyist who works for the Alliance had kind of implied that perhaps my interpretation of this was not correct, which is confusing because this county, city, town, or township, we kind of debated back and forth. Does that apply just to a fiscal body? Is it the executive of any governmental entity? Is it the legislative body of any governmental entity? And is it the fiscal body of just a county, city, town, or township, narrowed just to that fiscal body piece? So I read it, and we read it to say, no, it's the executive, legislative body, or fiscal body. That's the group of any county, city, or town. So we reached out to the public assets counselor and asked that very specific question. And you can see here, we reached the public access counselor. So would you agree that the plain reading of the new code section is stating it applies only to the listed bodies of county, city, towns, and townships? The response: yes. Just county commissioners, just city and town councils, and just township advisory boards, and any other governing body that meets in those chambers. So if you are not a city, a county, or township, the county commissioners, county council, city council, township trustees, this law does not apply to you unless, again, you hold your meetings in one of those groups' chambers. Now, the rationale for that is, well, all of these bigger, probably more funded organizations have the infrastructure to stream their meetings. So if you're going to have your meetings in there, then you have to go ahead and comply too. So if you do have to comply, what does that mean? For now, I'm just going to speak to who this applies to, and we can have questions later about who it applies to. But for everybody, this applies to. A governing body shall provide a publicly accessible platform on the public agency's choice of the following: a live transmission of the governing body's meetings, and archived copies of these live transmissions. And each archived copy of live transmission must provide access by link to the meetings, the agenda, the minutes, and or memoranda. So a governing body shall include on their website of live transmissions a link to watch these meetings, and then also archive copies of these live meetings must be available for 90 days. If a governing body doesn't, in fact, not have internet capability for live transmission of meetings, and I have seen this, that maybe you're in an area that does not have broadband yet, and your Wi-Fi is spotty. You still have to comply. You have to record those meetings and then put those meetings on your website. Again, maintain those for 90 days. This is where it says the public agency is subject to the following. It must have those for 90 days on the website for either downloading, or someone can come in and copy it via flash drive or something like that. But that's a requirement that while you're streaming these, you're also recording them. And if you're not able to stream, then you at least have to have a minimum recording. But the requirement is to stream if you have the capability. And this is where it says you have to have those available for the public to inspect. Again, without charge, like a link on the website where they can watch that, or they can come into the public agency with a flash drive and get a copy of that upon request during regular business hours. And a copying fee could apply like you would charge if somebody wanted a copy of a public record. Again, but this only applies for 90 days, and I assume this is the case because they don't want to bog down people's drives with a lot of memory and storage. So after 90 days, your IT person could probably have you set up something where they kind of roll off so you're not storing tons and tons of video content, which is not really a long period of time. Usually when people are doing research and wanting to watch their government, they find out about something, and by the time 90 days is rolled around, that video could be gone. And that's permissible in the statute. It only has to be retained for 90 days. This is also important because I've had questions about this already when people are kind of practicing their systems. If you are streaming, I had a county commissioners meeting that was streaming, and the law is not effective yet until July 1st, but they were still worried because it happened again, and their feed went out. And it was no longer live and streaming, and they have the bandwidth and they have the capability to do that, and they were worried they were going to get in trouble. The law thought about that. We all have internet problems. I had problems getting on the Zoom. If in fact the internet breaks down or something happens, that doesn't mean you have to stop your meeting. That doesn't mean anything changes. Keep recording that meeting even though the streaming is stopped, but it does not prevent the governing body from conducting its meeting. It does not affect the validity of any action taken at that meeting. And it does not violate this law in any way, shape, or form. Again, the law is being lenient, knowing that there's going to be technical difficulties if the streaming goes down. You can keep going with your meeting, just keep recording it, and then put a copy of it on your website when it's all said and done. Nobody's subject to any penalty or civil liability or criminal liability for that happening. There's no violation of the statute when that breaks down. So I know that was pretty quick, but there's really not a super ton to this section. I think the big, huge takeaways are, one, does this apply to you? Does this statute apply? And I think that, and I don't know the legislator's intent, but the way it was written for me, the way I interpreted it is that it only applies to, I'm gonna go back to that slide because I think that's a really important point. It only applies to the executive, the legislative, and the fiscal body of a county, city, or town, or township trustees. It does not apply to anybody else unless, again, it's a very important unless, because I think that a lot of smaller utilities and smaller towns, counties share space. And so if you're not your county commissioners, if you're not your county council, if you're not your town council, where clearly black and white applies, if you have their meeting in that room where they have their meetings, this law applies to you the same as it does to them. So with that, I will open this up to questions. And again, Kristen, I apologize because I know you're scheduled for an hour, but that's about as long as I could make this topic go. But
I think they'll be excited to have some free time today, to be honest.
But I have all the time that to answer any questions if anybody has any.
Andrew,
Yes.
This is Tom. I'm with the city of Lawrence. You mentioned the 90-day storage. Suppose a government agency streams through, say, YouTube. Are we required to still keep a storage of some sort ourselves for 90 days in case somebody wants to come and look at it? Or is the storage, say, on YouTube good enough?
Well, you need to provide access to it through your website. So I'm not familiar with the YouTube platform, but if you have an account with them or something and they store content for you for some period of time, I think as long as, that's your provider and your website provides a link to that YouTube storage database or however that works for a 90-day period, then you would be covered. It doesn't require you to host it in-house, but you do need to have a link on your website to view that for a period of 90 days.
And
so essentially some kind of link on your website to that actual YouTube, like it needs to be embedded or included on the website, not just on the YouTube. Correct.
Yes, it needs to be on the governmental entity's website, a link to that meeting. If it redirects you to a YouTube file, that's okay. But again, you need to link it from your website directly to that file.
All right, thank you.
Yep.
Hi, this is Amanda from the Anderson Township Regional Sewer District here in Milroy. So we are a regional sewer district and we hold our monthly meetings in our office. So am I understanding then at this time, we do not need to live stream?
That is my understanding as presented to me by the Indiana Public Access Counselor. And that is how I advise my regional sewer districts who hold their meetings in their offices, that this law, as its way is currently being interpreted, does not apply to those circumstances.
Okay, we might get used to it. I'm sure it'll come down, but right now that's just wanted to make sure I understood it correctly. So thank you very much.
That is the number one question I've had. I represent probably 12, 13 regional sewer districts, most of which meet in their offices. And they were elated when I told them this does not apply to them. And there was a lot of, like I said, this has been out there for a couple of years. So me and my partner, Chris, have been, putting this back and forth, reading every comma in that statute to see, man, it just seems like it doesn't apply. And then when we got the confirmation from the public access counselor, we felt really comfortable that obviously we can rely on that decision. One caveat I did notice is that when I went to do a little research on the public access counselor, and I noticed that our new governor has appointed a new public access counselor. So if I hear differently, I will get this out to Kristen that the new public access counselor has a different opinion, but I've got an opinion currently that I'm relying on until somebody else tells me otherwise. That's the way I'm going to advise my clients.
Andy, this is Herb with Hill Water Corporation in Mooresville. We are a membership-owned co-op. Sorry about that. Holds our meetings in our own office. We don't have to record or live stream anything either, do we?
Are you a governmental entity? Are you subject to open door law to begin with?
We're a 501c12.
So both the shorter answer is no, it doesn't apply to you because you're a co-op. But the bigger answer is too, is a 501c12. I don't even think you're a private corporation, so I'm not sure you're subject to the open door laws anyway. But I'm not 100% sure on that.
Okay.
Question about conservancy district having to live stream. No, they're treated just like a regional sewer district. Again, if the Conservancy District has their meeting in one of those chambers of an entity that is required, then the Conservancy District would have to live stream. But if you have a sewer treatment plant and you have an office there and that's where you hold your meetings, no, a Conservancy District would not have to live stream in that circumstances.
If you're not wanting to put your face or put yourself out there, you can also put it in the chat too, just like some of these people have been doing. I know not everybody wants to talk.
So there's a comment here, are there requirements for ADA compliance, such as transcripts? I'm not an ADA expert, but I wouldn't see why, if you're talking about ADA compliance with the website, that you wouldn't be exempt from any ADA requirements that you already have. So if your organization is subject to ADA accessibility on your website, then that would remain true.
Anybody else have any other questions for Andy? If you're thinking it, someone else probably has the same question. Awesome. All right, well, I appreciate your time, Andy. Hey, we saved everybody half an hour today. Look at that.
Okay.
Thank you so much for being on here. There's definitely some other laws that we're looking into, possibly hosting another training in the future. If you're familiar with House Bill 1459, the asset management law that's going to be going into effect starting in January. We're probably going to have some information rolling out more about that at some point. We're expecting some more information come this fall about that, but certainly stay updated with us, and also on our website, inh2o.org. I think it's /training. We actually have a brand new website right now, and there's should be trainings through the rest of the year on there. I think we have at least the next few months on there, so stay tuned for that. Lorian Johnston, our deputy director, is also on here. Do you have anything to add about trainings or anything you want to share on that? If not, I will let you all enjoy the rest of your day. Yeah.
I actually have an unrelated topic, a new law it's not in effect yet. That's going to go into effect July 1st that I'm just looking at because I find out about it today, that will require all boards, municipal corporations, to list on their website their board members, who appointed them, and their term. So every single board member will now have to be listed on your websites with their term and who appointed them.
Interesting. And when did you say that's slated to?
It goes into effect July 1st, but I just found out today. It was signed, I think, on April 10th, like the last day of the session. I don't know if it was
snuck in there.
Yeah, somebody snuck it in there. So I'm just finding out about it, and I'll get you more information when I do.
Yeah, when you get that out to me and we can push it out through our newsletter to everybody, we can definitely that information out. Awesome. If nobody else has anything, I just want to thank Andy for his time, and Carson Law, and all of you for being on here, and reach out to us anytime for any questions or support we can provide you here at the Alliance. Thank you so much.
Thank you.
Have a great day, everybody.